Item 25 WPS 653 of 2014.
Where is the document of equivalence?
Annexure 2 is. Annexure 2 is 89. May I read it for you? श्री रामचंद्र ओझा को उनके ग्रहण की तिथि से बिहार गृह रक्षा वाहिनी संगठन में जिला समादेष्टा आरक्षी उपाधीक्षक के समकक्ष के पद पर बिल्कुल अस्थायी तौर पर आदेश तक नियुक्त किया जाता है। आरक्षी उपाधीक्षक is duty superintendent. Thereafter, just to show the document, I am permitted to show some documents. Annexure 4, paragraph 18. Different issue was in that petition, but paragraph 18 may be seen just for historical perspective to show that there was principally
No, we will not look at it.
Okay.
Annexure 4 is something we will not look at.
Yes, then it is. Thereafter, my lord, we can see annexure 7. Annexure 7.
Annexure 5.
Five is the order of Honorable Patna High Court, but issue was that the Home Guard officers would be given the rank of IPS officers. Therefore, for that reason, I am not referring this order. Because in this writ petition, that counter affidavit was filed, saying that only for the purposes of pay fixation, there is equivalence. Nothing more, nothing more than that. Annexure 7. On 30th March 1996, the petitioner was promoted in the rank of divisional commandant equivalent to the post of superintendent of police. I may be permitted to read it. बिहार गृह रक्षा वाहिनी संगठन के प्रमंडलीय समादेष्टा अपर आरक्षी अधीक्षक के समकक्ष वेतनमान 3000 से 4500 श्री रामचंद्र ओझा संप्रति समादेष्टा केंद्रीय प्रशिक्षण संस्थान बेटा के को गृह रक्षा वाहिनी संगठन के अंतर्गत प्रमंडलीय समादेष्टा आरक्षी अधीक्षक के समकक्ष वेतनमान 3700 से 5000 के रिक्त पद पर तत्कालिक प्रभाव से अस्थायी प्रोन्नति दी जाती है। In the order itself, it is clearly and categorically mentioned that his post of the divisional commandant Home Guard was equivalent to the senior space to superintendent of police. Now we may kindly see as I stated earlier, since 1981 to 1995, there was equivalence of pay scale of the Home Guard officers and the police officers by virtue of either the administrative order or by the order of the Honorable High Court of Patna. This is the second case in which the petitioners who are aggrieved by the anomaly in the pay fixation of the rank of senior superintendent of police approached Honorable Patna. In this case, direction was given to consider their case, the case of grievance of the petitioner, and accordingly by annexure 10, the pay was fixed equivalent to the officers of the police department, or either of the deputy superintendent of police, or additional superintendent of police, or senior superintendent of police. Annexure 10 is. Second page of annexure. ऊपर विषय I am permitted to read विषय बिहार गृह रक्षा वाहिनी पटना के अधीन कार्यरत जिला समादेष्टा की कोटि के पदों पर
Annexure 8.
Yes. Annexure 8
is Pitman Committee recommendation.
Yes.
Does it say that it is equivalent?
In this case, entire order is not there, but page 19 has been annexed of that report, in which pay fixation has been fixed in page 135, last column, page 20, serial 25 magazine. Only to this extent it is there. But by an certain it will be clear.
So why have you annexed this? We will read the notification first and then annex it. What is this notification for? Is it relating to home guards?
Yes, sir. It's related to homeworks.
Home guard organization, page 135.
135.
35.
Yes. But from this, it is not very clear that's why I was not relying on this. But an extra
Here there is a fixation of pay for home guards.
yes.
Are you being paid as per this?
Till 1995, my case is, till 1995, I was getting the salary of the
Whatever
equivalent
you
to
are
the
getting.
superintendent of police. That will be clear from an extra 10 and 11. I am coming to that. And
Topple नहीं हो सकता.
yes, total, I am not arguing.
Since 95 you have been paid as a separate thing altogether. But in 1989, was your standing same as that of Deputy Superintendent of Police?
My lord, I will see, I will share 10 for a moment. Page 130. पहले उसका सब्जेक्ट एक बार देख लेते हैं. इसे बिहार गृह रक्षा वाहिनी पटना के अधीन कार्यरत जिला समन्वयक के पदों पर कनीय प्रवर कोटि वरीय प्रवर कोटि तथा सुपर टाइम कोटि के पदों पर परिवर्तन. नेक्स्ट पेज में है सीरियल 4
संपरिवर्तन दिनांक 1/3/89.
यस.
This is the same date by which this notification was given.
यस. सीरियल 4 में उसी प्रमंडलीय समादेष्टा आरक्षी अधीक्षक के समकक्ष सब जगह इट इज क्लियरली मेंशन कि जो भी मेरा पोस्ट है तो दैट इज इक्विवेलेंट टू द आरक्षी अधीक्षक. नाउ मेरा काइंडली सी annexure 11. Annexure 11 is very clear that my pay scale was 4,100 to 5,300. My name is there in serial 3 of this notification. And till 31st December 1995, I was getting salary as per this pay scale. But the day when I was promoted on 30th March 1996 on the post of the divisional commandant, equivalent to the superintendent of police, my pay scale was reduced for the reasons based on the responding authorities. And in this case, at the outside, I may say that the counter of state of Bihar has come, but the finance department has not filed any counter affidavit.
Which finance department? State of Jharkhand?
Yes. State of Jharkhand has not
You have
filed.
not filed any.
No counter.
Department of Home has filed counter.
Is that enough?
Enough to the extent that the
Department of Home, you don't need the, I will record it, that counter affidavit of finance department need not be filed.
I'm not saying that.
Then what are you
Since
saying?
Lordship has inquired that whether it is enough or not. I'm only assisting Lordship on that point, that it says that the issue with
Finance
respect
department is a party.
to,
Do you want to file any counter affidavit or you don't want to file?
Lordship का डायरेक्शन होगा हम फाइल कर देंगे.
Even if the finance department says that they don't want to file a counter affidavit, that affidavit should also be based on record, that they do not want to file a counter.
हम नहीं कर रहे, इशू बेस्ड है, हम वही कर रहे हैं. फाइल होना चाहिए, फाइल होगा भी. हम बस लॉर्डशिप का पहला जो क्वेरी था उसका आंसर दे देना चाह रहे थे. होम डिपार्टमेंट के काउंटर एफिडेविट से जो पॉइंट आया है निकल के, वो ये है कि नाउ दिस इशू हैज बीन डेलिबरेटेड बिफोर द पिटमेंट अपीलेट कमेटी. और अपीलेट कमेटी ने इनका क्लेम को रिजेक्ट किया है, एंड व्हिच वाज बाइंडिंग अपॉन द स्टेट गवर्नमेंट. ये इतना सा
तो
निकल गया है।
एपलेट कमिटी का जो डिसीजन है इन्होंने चैलेंज नहीं किया है।
हाँ, यहाँ पे आप
Challenge
उसके
किया
बाद
है
ही
ना?
है, हाँ, उसके बाद ही
किया है तो दैट इज द सब्जेक्ट मैटर ऑफ कंसिडरेशन। उसका अमेंडमेंट करके किया है, कैसे ही किया?
नहीं, that is under challenge.
अच्छा, ओके, दैट इज अंडर चैलेंज। तो दैट इज ऑलरेडी अंडर चैलेंज।
हाँ,
तो ये क्या स्टैंड हुआ कि एपलेट कमिटी ने रिजेक्ट कर दिया?
एक्चुअली ये पहले इसमें जो हम देख पा रहे हैं रिकॉर्ड से, पहले राउंड में डायरेक्शन हुआ था कि ये पे रिवीजन का इशू है, वो एक्सपर्ट कमेटी ही कर सकती है, सो देयरफॉर इट वाज डिमांडेड फॉर कंसिडरेशन बाय द एक्सपर्ट कमेटी। वो हुआ क्या कि दैट वाज रेफर्ड बिफोर द अपीलेट कमेटी कंस्टिट्यूटेड इन रिस्पेक्ट ऑफ 6 पीआरसी। उन्होंने वो जो एक्सपर्ट कमेटी थी उन्होंने डिनाई कर दिया कि सिंस द मैटर इज अराइजिंग आउट ऑफ 5th पीआरसी एंड माय जुरिसडिक्शन इज विद रिस्पेक्ट टू 6th पीआरसी, this committee cannot decide.
Somebody has to decide, no? Then
Ultimately again, वही
ये
बात
क्या
है।
है? मतलब
Again,
सब्स्टिट्यूशन फाइल हो गया क्या इसमें?
again,
ये कब से चल रहा है? 2014
अब
से?
उसके बाद क्या हुआ? हाँ, उसके बाद क्या हुआ कि अब अल्टीमेटली उस लाइट में फिर ये ऑर्डर जो है वो पास किया गया है डिपार्टमेंटल सेक्रेटरी होम के द्वारा। फाइनेंस
वो तो नहीं कर सकते हैं ना। वो तो भाई फिटमेंट कमिटी जो भी होगी, जो आपके 5th पीआरसी, 4th पीआरसी, whatever, right? If it has been dissolved, the somebody has to that has to be reconstituted for this purpose.
अब इसमें हम एट दिस स्टेज जो हम हमारे पास इंफॉर्मेशन है, लॉर्डशिप कहेंगे वो रिकॉर्ड पे आ जाएगा तो ज़्यादा बेहतर होगा, बट फॉर द सेक ऑफ असिस्टेंस हम कह रहे हैं कि 4th और ये 5th और 6th का जो अपीलेट कमेटी वगैरह बनी थी वो तो डिसॉल्व हो गई, लेकिन बाद में बाय द ऑर्डर ऑफ दिस ऑनरेबल कोर्ट एक परमानेंट पे अनोमली कमेटी फाइनेंस डिपार्टमेंट के अंदर में है। सिर्फ उसका कोरम चेंज होता रहता है मेंबर्स के
But there is a
रिटायरमेंट
permanent body to take care of this.
to look into the matter relating to pay anomaly.
तो आप इतना ही बोल दीजिए ना, फाइनेंस डिपार्टमेंट को बोलिए कि इतना रिकॉर्ड पे ले आने, हम भेज देंगे उनको। We are not going to decide it over there.
Exact.
But that affidavit should come from the finance department.
हम पहली बार इसको
क्योंकि
देखे
पे
हैं।
अनोमली की बातें, it has got lot of repercussions, right? इसलिए वो equivalence, पे
And even
anomaly,
that has to be decided by the expert committee.
these are technical matters, has to be decided by expert committee.
Lordship is right. That's why I was pointing out कि ये रिकॉर्ड जितना हम देखे उससे आपको ये
तब ये इतना जो मोटा बना दिए हैं तो 14 से लेके अभी तक 24 तक किस लिए बना दिए?
बहुत कम डेट पे ये हुआ भी है, पता नहीं। काउंटर तो बहुत पतला सा है मेरा।
It is not also a paragraph wise paragraph.
कोई बात
ठीक है।
नहीं। You see, we are not going to decide the equivalence. एक केस में हम डिसाइड किए थे that order has been set aside, so I will not repeat it. I learn from my mistakes, and any order which is set aside, I take care of that. मतलब एकदम साफ बता रहे हैं। एक केस में काउंटर नहीं आया था in spite of repeated
But
opportunities.
second time हो सकता है कि that is full.
नहीं, ऐसा नहीं कर सकते। ऐसा नहीं कर सकते हैं, ठीक है? Otherwise also you are not remediless, correct? So you have to go there.
Already earlier read petitioner was filed with this petitioner in the fact end of his.
सही जगह पे जाएंगे तो जल्दी डिसाइड हो जाएगा। टाइम फ्रेम सब आपको
But
पता है।
let him at least file paragraph.
You find your affidavit.
Direction में give him the paragraph wise replies.
No, not required. Not required. Parawise comment इसलिए यहाँ पे नहीं होगा because they are to be relegated to an appropriate authority for decision. Why should they disclose whatever they have to say? They will say there only. वहाँ पे आपके हर चीज का parawise comment देना।
हाँ तो दिक्कत है।
कोई दिक्कत नहीं।
At least यहाँ पर paragraph comment आ जाता तो।
नहीं। जैसे आप उस केस का काउंटर एफिडेविट यहाँ पे लगाए हैं, फिर इस पूरे पिटीशन को उठा के वहाँ पे लगाएंगे, ऐसे नहीं चलेगा।
वो just to show कि equivalence है। That is one additional document.
इस तरह से
मेरा throughout जो appointment letter
इस तरह से नहीं हो
और promotion letter है, तो सब जगह equivalence of the post mention।
WPS number 653 of 2014. Counsel for the parties are present. The matter relates to fixation of pay. The learned counsel for the petitioner has submitted that the petitioner was always treated, the post of the petitioner was always treated at par with the post of Superintendent of Police. But subsequently, upon his promotion, he was put as at a lower pay scale. The Learned Council for the respondent has submitted that at one stage the matter was referred to the pay revision committee. क्या बोलते हैं? Pay revision committee. But the state sixth pay revision किसके पास भेजे थे?
ये जो रिकॉर्ड से ला रहा है ये देखा
To the fitment committee. Fitment committee sixth pay revision. But no relief could be granted to the petitioner as the pay anomaly was relatable to the previous pay revision. है ना? यही बोल रहे ना आप?
हम रिकॉर्ड से दिखा देना चाहते हैं ये ऑर्डर हुआ था 84 ऑफ 2019 में WPS 84 ऑफ 2009 सॉरी ये इसमें रिप्रेजेंटेशन डिस्पोजल का ऑर्डर था ये पेज नंबर 168 पर है ये इनिशियल राउंड ऑफ लिटिगेशन है
The Learned Council has submitted that in the earlier round of litigation filed by the petitioner in WPS number 84 of 2009,
I hereby direct concerned respondent
the
to decide
petitioner was relegated to file a representation.
It was referred by the department
Then it was referred by the department to the fitment committee.
Fitment appellate committee
Fitment appellate committee.
ये पेज नंबर 172 से आया such has filed a petition dated such and such before fitment appellate committee set up common issues issuance of pay revisions.
Fitment appellate committee, but the appellate committee
In 173 में appellate committee
refused to redress the grievance of the petitioner by observing that the petitioner was seeking pay revision with effect from 1/1/1996 and his request related to 5th Fitment Committee.
fifth pay revision
Where they can Fitment Committee regime/period, which was not the terms of reference of the concerned committee. This order is under challenge?
ये तो
नहीं.
okay
And ultimately, the order was passed as contained in Annexure 18 by the Home Department of the State of Jharkhand,
principal secretary
dated 5/10/2010, which was against the petitioner and is under challenge in the present proceedings. Although he has also submitted that, as per his knowledge, instruction तो नहीं लेकिन
information
as per his information, there is a permanent committee to deal with
PNM
pay anomaly, which is working under the finance department. And the matter relating to pay anomaly being technical in nature is required to be first looked into by the pay anomaly committee. During the course of proceedings, it transpired that no counter affidavit has been filed on behalf of the
finance department
finance department,
government of Jharkhand
government of Jharkhand. Within bracket, respond number 6. Counsel for the state is directed to seek instructions and file a counter affidavit on behalf of respondent number 6, indicating as to whether the grievance of the petitioner can be referred to the pay anomaly committee as argued by the learned counsel for the respondents,
As informed.
as informed by the learned counsel for the respondents. कब तक होगा?
3 weeks में दे।
इसी साल हो जाएगा ना?
हाँ, इसलिए हम भेज ही देना ज़्यादा अच्छा है। तो इतना पर भेज भी सकते थे।
The affidavit be filed by 28th of November. Pose this case on 5th of December in the supplementary list.
Okay.
Item 26 WPS 1212 of 2015.
ये क्या है?
Dismissal assignment.
कुछ है कि ऐसे ही है? बताइए क्या?
The advertisement was floated in the year 2004. The petitioner applied from the district of Chhattisgarh for the post of police constable. After clearing the
List
physical,
of dates वगैरह कुछ नहीं बनाए हैं?
नहीं बना देंगे इसमें जरूरत पड़ सकता है क्योंकि दूसरा तीसरा राउंड ऑफ लिटिगेशन है 3 बार डिसमिस हुआ है तीसरा बार
क्या आप कह सकते हैं? 3 बार डिस्कस हो गया। इसी एक ही इंसिडेंट से 3 बार डिस्कस।
तीनों एक ही चार्ज एक ही है बार-बार एक ही चार्ज के लिए डिसमिस हो रहा है
बार-बार गलती करते हैं तो बार-बार चार्ज।
नहीं चार्ज इंटरपोलेशन इन मास्टर चार्ट का है इंसेप्शन
तभी से चल रहा है।
तब से चल रहा है और इसमें बाकी सारे लोग नौकरी कर रहे हैं सिवाय पिटिशनर के और सिमिलर सिचुएटेड केस
आपका रिटायरमेंट एज पहुंच गया?
नहीं
अभी नहीं पहुंचा। 10 साल तो हो गया।
एलपीए के ऑर्डर से कवर्ड है सिमिलर सिचुएटेड पर्सन के उसमें सेट असाइड हुआ डिसमिसल और इसका भी ऑर्डर हमेशा सेट असाइड होता गया है एक से एक लिस्ट ऑफ डेट्स बना दीजिए
लिस्ट ऑफ डेट सही से बना दीजिए, अदर साइड को भी दे दीजिए बस आप
ठीक
इसका 10वां साल 11वां साल नहीं लगना चाहिए।
नहीं ठीक है
27/3 को फाइल हुआ 15
लिस्ट ऑफ डेट
296 से कवर्ड है।
हां रंजय कुमार सिंह एलपीए 296 ऑफ 2007
स्क्वेयरली कवर्ड।
हाँ दोनों को सिमिलर से एक ही चार्ज हुआ था दोनों को हटाया गया था दोनों 2 बार डिसमिस हुए रंजय सिंह को रिस्टेट कर दिया गया इनको हटा दिया
आपको क्या बोलना है?
Your Lordship may see the.
What is the difference between the case of the petitioner and the Ranjay Kumar Singh?
Yes, Your Lordship, that is why Your Lordship may kindly come to page Annexure 7, page number 43 of the writ petition, wherein the petitioner approached this Honorable High Court for the first time. Annexure 7, page number 43.
Miss Andher?
The last operative portion. Page number 47, paragraph 17 I am placing. In the light of the above facts and circumstances and the discussions made, these writ petitions are allowed. The orders impugned in WPS number so and so are hereby quashed. The respondent authorities shall allow the petitioner to join their post on the basis of the letters of appointment given to them. However, if the respondent authorities intend to take any action against the petitioners on any specific charge, they would be at liberty to take any action against all or any of the petitioners, but only after serving them charges and conducting inquiry and by giving the individual petitioner a reasonable opportunity. So, by this order, it is clear that liberty was given to us by virtue of this judicial order that we can take any action on any specific charge, even if the earlier memo of charge was quashed in this case, Your Lordship. Subsequently, we have issued a new memo of charge, which is that
Based on the same allegation.
Same allegation.
Your Lordship, the petitioner has to first prove that earlier memo of charge and this memo.
What to what I will specify, my lord, the wording the same as the motion.
That
Let me understand, how does he distinguish the case?
that the earlier memo of charge and the new memo of charge is exactly similar in nature. Your Lordship.
There is no question of not having a dissimilar nature, because on technical grounds the proceeding was set aside, isn't it?
Yes, sir.
So therefore there has to be same charge, apparently. You do not know. Apparently there has to be same charge. Then what happened? In this particular case, Ranjan Kumar Singh and the petitioner, both of them were party.
No.
In this case, Ranjit Singh case has been illustrated, my lord, at para 16 of the same judgment. In the case of
Para number 16.
Yes, of the page 47. The para 17 my friend was reading, para 16 my kindly listen. In the case of Ranjit Kumar Singh, supra identical issue came up before this court for consideration, where the writ petitioner was admitted not identified to be the category of 932 excluded person, and he was allowed to join the post of constable, and later his appointment was terminated.
Now just pause.
Yes.
Okay. Right. Then what happened? After this,
After this, Your Lordship.
numerous orders must have been passed thereafter. Is
after-
there any discussion of the case of Ranjay Kumar Singh in those cases? Because this judgment is very loud and clear, referring to the judgment of Ranjay Kumar Singh under identical circumstances. Is there any reference of this judgment in the impugned orders passed by him?
The impugned order, Your Lordship, it has only been discussed with regard to the paragraph which I have read, Your Lordship. It is page number 108 of
And
the.
you will not read the rest of the portion of the judgment. But the judgment is loud and clear that under identical circumstances this has happened. You did not like the face of the petitioner. Not good looking. Yes? When the judgment clearly says that the case is otherwise covered by a particular judgment, by passing fresh orders, will you not take care of that judgment?
That does not come up in the
That is sufficient.
dismissal order.
That is sufficient. What else do you need? We are on your arbitrary action, right? You just pick up the last portion.
Of the dismissal order.
दिखाइए कहाँ है आपका मतलब? The allegations against Ranjay Kumar Singh and you, similar and arising out of the same transaction.
Same transaction. Same appointment date, everything same.
Have you annexed a copy of the charge memo to Ranjay Kumar Singh?
That is not.
In the judgment of Ranjay
Ranjay
Kumar
Kumar-
Singh, it must be mentioned.
Yes. important aspect I want to show you. Now, in case of Ranjay Singh, again what happened? They reinstated and again they proceeded similarly in same fashion. Now thereafter, this Ranjay Kumar Singh approached this honorable court by filing another petition 2148 of 2010. This is the order, my lord, if my lord tells you. In this case also the department has been asked to not to proceed, take any coercive action against the petitioner, and he is allowed to work till date.
ये कहाँ है? ये केस कहाँ है?
ये
2148
ये
2010
अभी
उसका स्टेटस क्या है? 2010 से ये केस चल रहा है।
ये फाइनल ऑर्डर है।
ये फाइनल
हाँ,
ऑर्डर।
ये फाइनल ऑर्डर।
And thereafter no action was taken
No,
by the
nothing.
superintendent.
He is working. Even this रेट पिटीशन से पिटिशनर के साथ साथ और भी लोग सात आठ लोग हैं, सब काम कर रहे हैं सिवाय पिटिशनर। What had happened in the appointment of 1/2004 that after inspection, my lord, it was found that 932 candidates are the beneficiary of malpractices. Now these again these 932 candidates, my lord, a case was LPA was preferred before this honorable court. That was Krishna ji and others versus state of Jharkhand. In that case, my lord, the honorable division bench categorically held कि 932 लोगों को छोड़ के सबको अपॉइंट करना है। ये 932 बस बेनिफिशियरीज हैं। ये क्लियर हुआ था इस जजमेंट में, और ये पिटिशनर 932 में नहीं है, ये स्पेसिफाइड है सब जगह कि ये उसमें नहीं है, उस लिस्ट में ये उस 932 में नहीं है, ना ये ना रंजय सिंह ना जो पहले बिग पिटिशन है। ये कृष्णा जी का ऑर्डर है। 932 को बस छोड़ना था, उनको आउट करना था, विदाउट द बेनिफिशियरीज। दिस वाज द वर्डिंग्स ऑफ द डिवीजन बेंच।
ये सब फैक्ट तो आपको लाना पड़ेगा।
हाँ, ये सारा मेरा प्लीडिंग्स में।
ये दोनों ऑर्डर्स।
हाँ, सब एवरीथिंग।
इट इज देयर।
हाँ, इट इज देयर।
इसको रखिए।
हम बस अलग से दिखा रहे हैं।
सुन लिया आप कहानी, स्टोरी सुन लिया, अब बस तैयार हो गया, आप अपना रिटन सबमिशंस करा लीजिए। यू हैव टू डिस्टिंग्विश हिज केस फ्रॉम रंजन कुमार सिंह। और उसका फाइल दबा के रखा गया है ना? अब वो रिटायर हो जाएंगे तब निकलेगा फाइल कहीं से, छुपा हुआ कहीं पे रखा हुआ होगा। यस, धनंजय कुमार सिंह का फाइल कहीं पे तो रखा होगा ना, कि डिस्ट्रॉय हो गया? डिस्ट्रॉय भी हो सकता है। 2010 से लेके आज तक क्या कर इलीगल अपॉइंटमेंट को 2010 से लेके आज तक 15 साल you allowed him to work, isn't it? According to you, it is illegal. We do not. इसका नोट्स बना लीजिए।
जी।
WPS number 1212 of 2015. Or the learned counsel appearing on behalf of the parties. The matter relates to dismissal of the petitioner. The learned counsel submits that the case of the petitioner is similarly placed as that of one Ranjay Kumar Singh, whose order of termination has been ultimately quashed by this court by judgment dated 5th of August 2009 in LP number 296 of 2007. He submits that the petitioner had also moved this court earlier in writ petition being WPS number 4032 of 2007 and other analogous cases, and in paragraph 16 of the state judgment, the reference of the case of Ranjay Kumar Singh has been mentioned, and ultimately the order of termination of the petitioners was set aside in the batch of cases. He has also submitted that there was an observation that if the authorities intend to take any action against the petitioners on specific charge, they would be at liberty to take action against all or any of the petitioners, but only after serving them charge and conducting inquiry by giving individual petitioners a reasonable opportunity of being heard in accordance with the principles of national justice. The learned counsel submits that the charge which was subject matter of consideration in WPS number 1032 of 2007 with 4032 of 2007 was again issued to the petitioner, and ultimately the petitioner has been terminated. The learned counsel submits that there is no discussion of the similarly situated persons, namely Ranjay Kumar Singh, in the impugned judgments, in the impugned orders. He has further submitted that Ranjay Kumar Singh was proceeded again by issuing a charge memo
Yes, similar fashion.
in similar fashion, and his services were terminated, which was subject matter of litigation in second round by him
WPS 2148 of 2010.
in WPS number 2148 of
2010,
2010,
Annexure 15,
Annexure 15,
last annexure.
and the said writ petition was disposed of by directing the authority to, by directing the Superintendent of Police Hazaribagh to consider the show cause / representation of Ranjay Kumar Singh and pass a reasoned order in accordance with law within a period of 8 weeks. It was further observed that till the final decision is taken by Superintendent of Police, no coercive steps shall be taken against Ranjay Kumar Singh. The learned counsel submits that the final order in the writ petition was passed on 23/7/2010, and the respondents did not take any action thereafter, and Ranjay Kumar Singh is still working. He submits that many similarly situated persons
Who were
are-
between the analogous cases.
who were with the petitioner in the batch of cases in WPS number 4032 of 2007 and other cases are still working, but only the petitioner has been left out. he submits that only 932 persons were excluded from appointment in the entire list, and the name of the petitioner does not figure in 932 persons. And therefore, there is no reason to keep the petitioner out of service. ठीक है? इनका तो सारा कहानी लिखा दिया, अब आप कब करिएगा ये बताइए. Learned counsel for the respondents prays for adjournment to prepare himself in the case and also to seek instructions as to whether all the persons who were involved in WPS number 4032 of 2007 and other analogous cases, and also Ranjit Kumar Singh, as pointed out by the counsel for the petitioner, are working in the department, and under what conditions they are working. A supplementary affidavit be filed to this effect. Let the supplementary counter affidavit be filed. कौन फाइल करेंगे? Superintendent of Police Hazaribagh.
Yes.
The supplementary affidavit be filed by respondent number 4, disclosing true facts in connection, disclosing the present position in connection with the aforesaid persons. Let the affidavit be filed by 28th of November, post on 5th of December. इतना टाइम लगता है हम लोग चीजों को समझने में, धीरे धीरे करते हैं, देखते हैं. अच्छा ठीक है, अंडर द सप्लीमेंट्री प्रोसेस करें. आप रिजॉइंडर फाइल कर देंगे तुरंत? If any.
Item 27, first appeal 139 of 2025.
Yes. Miscellaneous appeal would like. We are posting some of the cases on next, I think. Fifth को रखे हैं.
There is a judgment of the Honorable Patna High Court.
पटना हाई कोर्ट आप पहुंच के झारखंड हाई कोर्ट का जजमेंट देखे नहीं है.
Consensus.
कुशेश्वरपुर पे कौन सा जजमेंट?
Yes, yes.
इसको हम लोग किसी दिन रखे हैं, उसी दिन रखते हैं. फिफ्थ को रखें ना सर? So the impact of court fees is very important.
Friday को रखें.
इम्पैक्ट ऑफ प्रोबेट केस में तो कोर्ट फीस चुना ही जा सकता है, नहीं?
नहीं, प्रोबेट जिस समय ग्रांट होता है
हाँ,
उस समय वैल्यूएशन पर स्टैम्प ड्यूटी है।
स्टैम्प ड्यूटी लगता है ना,
कोर्ट फीस 250 रुपये।
कोर्ट फीस 250 रुपये लगता है, और फर्स्ट अपील में भी
फर्स्ट
कोर्ट
अपील
फीस
में अगर डिक्लेरेटिव सूट है तो 250 रुपये, अगर जनरल टाइटल सूट है डिपेंडिंग अपॉन वैल्यूएशन ऑफ द सूट
हाँ,
तो उसमें
प्रोबेट
लगेगा
केस का
$1.
प्रोबेट केस का फर्स्ट अपील में कितना कोर्ट फीस लगेगा? 250 रुपीस।
250। अभी तो कल फाइल किया, कल फाइल किया 250। अगर अपना डिवीजन बेंच आ गया है तो नेचुरली वो ऑल अर्लियर केसेस हैव बीन टेकन।
तो जब अपना डिवीजन बेंच आ ही गया है तो फिर हम लोग को फिर उसी अनुसार चलना पड़ेगा, क्या करेंगे?
एमए करें, एमए तो कल भी फाइल करना है, कल भी फाइल किया 299 का जब भी होगा एमए फाइल होगा।
लेकिन इसमें तो बोल दिया है
यह तो इसीलिए तो हम बताया कि डिवीजन बेंच का जजमेंट है, ये हो सकता है दोनों, बट इसका कंक्लूडिंग पार्ट देखा जाए, ये मैटर रेफर हुआ था यही इसी चीज के ऊपर कि वेदर फर्स्ट अपील विल राइट और वेदर मिसलेनियस अपील विल।
it cannot be termed as an appeal under section 104(1) of the CPC.
Since it is latest judgment of this law, therefore I refer it.
That's right.
But still we are filing miscellaneous appeal against judgment passed by probate court.
And it is being entertained.
Entertained regularly. पटना
Right?
इसी जजमेंट की वजह से रेफर
Section 96 only talks about appeal from original decree.
original.
It does not talk about appeal from original judgment.
Appeal from judgment.
It does not talk about appeal from
As
judgment.
it in order 41.
Yes.
पहले डिग्री का था, that has been amended by judgment. Order 41 में देखा जाएगा amendment जो है.
Order 41 का rule.
So, one, appeal from appellate decree.
Order 41 का rule मानना.
Yes.
appeal from original decrees.
नहीं वो amend हो गया मैडम, वो amend हो गया है by amendment number 78 which is 2002 17/2002 में. That was
Substituted by
that was
decree appeal from judgment court,
yeah.
वो change करके
That
किया.
has been decree से judgment.
और ये कुशेश्वर कोर्ट में कब का जजमेंट है? प्रायर टू 2002 अमेंडमेंट?
ये नहीं अभी वाला ये
अभी तो है ये कुशेश्वर वाला
17 का.
जो है
17 का.
17 का.
पटना का जजमेंट जो है 17 का है. I so far I remember this judgment, due to this judgment the matter was referred to division bench,
Yes.
Patna bench. Probably it might have been quoted in the division bench.
Yes. They say that the final judgment amounts results in the form of a decree.
Yes. These all matters read so far I remember. It has been taken note by division bench. अभी तो सडन हम निकाल के आपको रेफरेंस दिलवा देंगे, लेकिन
But miscellaneous appeal is also accepted. तो सुप्रीम कोर्ट का जजमेंट नहीं है.
हाँ, इसमें इन देखा गया जो पारा 1 है, पारा 38 का तो पारा 1 डिवीजन बेंच जजमेंट पढ़
Last and
Yes.
the orders passed finally by the competent authority granting probate or administration or refusing the same in the contentious case may be a judgment under section 2 clause 9 of the CPC but not a decree stricto sensu.
एक बार इसमें थोड़ा सा गला देख लीजिए. मैटर लेट मैटर पुट अप ऑन नेक्स्ट वीक. फ्राइडे को एक मैटर रखी है. इस डिवीजन बेस्ड जजमेंट देख के जैसा डिसाइड करना होगा. If a relative of the view other than division bench, matter is required to be referred to larger bench.
वो तो आप लोग असिस्ट करेंगे.
नहीं.
आपको क्या ही बोलना है?
नहीं, वो तो कोर्ट डिसाइड करेगा ना.
नहीं तो आप लोग का जो आर्गुमेंट होगा उसी पे ना डिसाइड करेंगे.
हाँ, आर्गुमेंट तो हम लोग ये मस्ट अपील फाइल किए. आप हमारा भी कहना है, कोर्ट का भी कहना है कि शुड बी
ऐसा हमको प्राइम बेसी लग रहा है.
लग रहा है.
क्योंकि ऐसा जजमेंट
इसीलिए जजमेंट मांगा गया तो सवेरे तो हम निकलवा
सुप्रीम कोर्ट का कोई जजमेंट इसमें नहीं है.
है. समझते कि रेफर किया हुआ होगा, बट आई विल हैव टू लुक इट.
ठीक.
अब तो जब रेफरेंस हम मिला तो हम देखेंगे. ये पटना ही तो उस समय पटना ही साइट हुआ था. एवं देयर इन दी कोर्ट. इसी के वजह से मैटर रेफर हुआ था.
Filing number first appeal number 139 of 25. This first appeal has been filed against the under section 299 of Indian Succession Act 1925. the counsel for the appellant is directed to examine as to whether the first appeal would lie or miscellaneous appeal would lie. Post on next slide. Terms of reference to division bench का था वो यही था whether decree is to be prepared in the probate case and whether a contentious proceeding referred under section 295 of Indian Succession Act 1925 has the same meaning as suit filed under section 26 of the CPC.
Therefore, the Patna judgment in the year 2017, the latest judgment was passed at that point of time, and it was referred by one of the lawyers.
Next slide.
हम भी देख लेंगे उसको.
हाँ देख, अगर मान लीजिए कुछ भी हम लोग का कॉन्फ्लिक्टिंग व्यू कहीं नहीं है, खास तो ओनली सुप्रीम कोर्ट, नो अदर कोर्ट. हम लोग का अपना कोर्ट का है तो हम लोग इसी को ऑन
ठीक है, हम देख लेंगे उसको.
एक बार थोड़ा देख लीजिए, अगर कोई कॉन्फ्लिक्टिंग व्यू नहीं है तो वी विल गो बाय दिस. फर्स्ट अपील वुड लाई, आप अपना मिसलीनियस अपील भी करते रहिए, फिर देखा जाएगा क्या होगा.
The first appeal में आपके होने का खास मतलब I
क्या
have to introduce Mrs. Bharti. क्या
She
ये
needs no
इसका
introduction.
written appearance of civil side.
अच्छा.
Therefore,
Welcome to the civil side.
Item 28, first appeal 150 of 2025.
this is.
What is it, madam?
Because this is against the decree wherein it was for declaration of right, title and interest matters, and that has been dismissed on absolute technical grounds, which has been challenged before us.
What is that technical ground on which it has
So
been
this may
dismissed?
kindly see the last paragraph of the portion of the order, 20th May 2024 order.
Para 14 पे कांगे.
It requires examination of the records. Unless we examine the record, कैसे होगा?
नहीं बिना उसके नहीं होगा. Appearance के लिए आज के दिन admission stage में only to introduce है.
Para 14 was the kindly see.
I've seen. We admit issue notice. Otherwise, it is in order. Otherwise, it is in order.
Yes,
This
sir.
was-
Yes, yes.
First appeal number 150 of 2025. अपने appearance में. Admit issue notice to the respondent number 1 and 2 for which requisites under speed post be filed within a period of 1 week. Call for the records from the concerned court. Office to track speed post delivery. Post this case on 26 November.
हम लोग को भी अपना
Call for the records.
लाइफ क्रिएट करने में अच्छा लगता है कि हमारे लाइफ में भी लोग तैयार हो.
हाँ.
She is practically well ready.
नहीं, she is always ready. वो अलग बात है कि सब्जेक्ट जो मिलता है वो आदमी करते हैं ऐसा. She is always ready.
हम लोग भी अब कितना भी 74 के हो गए, पता नहीं कितना है.
तो इसीलिए तो आपको बोल रहे हैं कि 20 एडवोकेट्स का नाम दीजिए.
दे दिए बट उसके बाद लिस्ट है
50% फीमेल है ना उसमें.
23 25 आ गए. नहीं फीमेल 20% बट हैं 5 और 6.
अभी खोज के निकालिए.
She is also
हाँ, she is also.
one of the members.
खोज के निकालिए फीमेल्स को भी.
क्या देख
हम बस सबको लिस्ट दे दीजिए, सबका फोन नंबर दे दीजिए और सबको हम यहाँ से, हमारे पास कोई ऑप्शन ही नहीं है because I am finding it.
नहीं we are ready to help you.
Item 29, first appeal 153 of 2025.
Yes.
partition सूची वहाँ पे
of the appellant and
It is for admission.
it's a partition.
It is for admission.
Yes, for admission.
आपको पहली बार देख रहे हैं. What's your name?
I have already settled in the partition, so the sons has been ready. And the
We need to admit it formally. FA number 153 or 25. Admit. Issue notice to the responding number 1 into
1, 2, 3.
to the respondents. For which requisites be filed through speed post. For which requisites be filed within a period of 1 week. Call for the records from the consent court. Post on 26 November. Office to tracks and post. Awaiting service to court. Communicate.
Item 30, first appeal 123 of 2025.
Admission.
Same order?
Same.
Respondents one.
Notice. 18 respondents.
सबको स्पीड पोस्ट से कर दें.
Speed post.
Respondents free speed post and notice है. ठीक है. Call for the records. Communicate. एक हफ्ता में कर दें.
2 weeks.
2 weeks का. तो आपका अगले साल कर देते हैं.
जी.
You are so happy.
I am not happy. I am not happy. I am saying that it is automated will be given after 2 weeks.
तो आप एक हफ्ता में नोटिस करेंगे तो इसी साल डेट देंगे 26 तारीख.
हाँ, एक सप्ताह कर देंगे.
एक हफ्ता में कर दीजिए 26 तारीख कर दीजिए.
ठीक, ठीक.
Office to track speed post.
Item 31, demand appeal essay, triple to 2025.
Yes.
But petitioner was when as a TJ replied. At that time, he moved a bail application before
Before the
order, rejecting the bail.
this petitioner.
Now, here, it has been transferred to Trillions Court.
That's right.
And the bail application was rejected. The stage of the case is not out of 8 witnesses, 5 have been examined.
So,
The expertise saying not given direction will be given to the current court.
how many witnesses have been examined?
8, 5 examined.
5 have been examined. You want your expeditions
Yes,
right?
but there's no use for it. The larger the
Criminal appeal SJ 222 of 2025. Any objection for expeditious trial? Are you ready to produce the witnesses?
Yes,
This appeal has been filed against the order dated 21/1/2025 passed by the Executive Sessions Judge 1 from Children's Court Dhanbad in miscellaneous criminal application number 2065 of 2024 in connection with GIPT PS case number 73 of 2023 corresponding to TR case number 1484 of 23 arising out of children's case number 9 of 2024, whereby the applicant's prayer for grant of regular bail has been rejected. The applicant is facing trial by submission of charge sheet on 9/7/2024 under section 147, 148, 149, 302, 504 and 506 of the IPC. The learned counsel for the appellant has submitted that the appellant at relevant point of time was claiming to be juvenile and less than 16 years of age, less than 16 years of age, and was granted, and the prayer for bail was rejected by the Children's Court by the order dated 20 June 2024 in criminal revision number 1419 of 2023. The learned counsel for the appellant has submitted that as of now, out of 8 witnesses, out of 8 witnesses, 5 witnesses have already been examined. कौन-कौन बच गया? Informant,
Doctor and one at IO. And one is
doctor, I know.
just you go lead. That is the one.
And mainly official witnesses are to be
Yes, doctor
examined.
and I.
Doctor and I. And one more witness. The learned counsel submits that he would be satisfied if an observation is made for expeditious trial of the appellant who is in custody since 22/6/2023. The learned counsel for the opposite parties. आप भी हैं private respondent? आपको तो कोई objection नहीं होना चाहिए. The learned counsel for the opposite parties, private opposite party and also appearing on behalf of the state, have no serious objection so far as prayer for expeditious trial is concerned. They submit that the counsel for the state has submitted that the state would ensure prompt production of witnesses as and when directed by the court. The learned counsel for the, after having heard the learned counsel for the parties and considering the limited submissions made by the learned senior counsel for the appellant, it appears that the trial is at the fag end and primarily official witnesses are to be examined. In such circumstances, this court is not inclined to interfere with the impugned order refusing bail to the petitioner. However, it is observed that the learned court shall make all endeavour to expeditiously conclude the trial without giving unnecessary adjournments. That should be sufficient.
Yes.
Let this order be communicated through fax. Disposed of.
Item 32 CRNT 512 of 2025.
Last of the notice but the report address is not located.
You have deposited the amount.
Yes, yes. But depositing is to notice to the opposite party. The report of the notice not address is
Not found. Insufficient address.
फर्स्ट टाइम ऑलरेडी अपील किए हुए थे रिवीजन में ये तो मॉडिफाई में वापस आ गया उसमें एक के सामने से रिपेयर किया फिर एक सेकंड टाइम के लिए
अब इसलिए एक किसानी से बात की है, कर लीजिए ना उनसे बात। अब काउंसिल से पूछना चाहिए, उनके पास सब पूछो।
ये सेकंड वाला
आप उनसे बात कर लीजिए, वो कोर्ट में ही होंगे, अभी गए नहीं होंगे। उनको बुला के लेके आइए, नहीं तो अगला हफ्ता तो अपने चला जाएगा।
Item 33 criminal appeal.
वो 4:30 बजे के पहले कभी जाते नहीं है कोर्ट में। He never goes, he never leaves the court before 4:30. सब पता कर लीजिए।
Item 33 criminal appeal is 533 of 2025.
Earlier rejected project. There is a specific allegation against another person who has assaulted to the victim.
Status क्या है?
Status मैंने एक बार फिर से देख लिया जाए। लॉर्डशिप के द्वारा मांगा गया था स्टेटस रिपोर्ट 2 बार। आर्गुमेंट पर 1.5-2 साल से चला आ रहा है। फिर से डिफेंस फिर से रिकॉल करके एविडेंस के लिए फिक्स कर दिया गया, फिर डिफेंस एविडेंस के लिए प्रोड्यूस कर दिया गया, फिर आर्गुमेंट पर कर दिया। अभी यही खेल होते चला आ रहा है और हम कस्टडी में हैं 22/2/2022 से और वो एक सभी का बेल हो चुका है 22/2/2022 से।
प्राइवेट रिस्पोंडेंट कहाँ है? बिना उनको सुने तो ऑर्डर नहीं कर सकते।
नोटिस तो हुआ था।
नोटिस हुआ था? क्या किया? कौन से दिन नोटिस हुआ था? No, notice has never been issued. Mandatory है ना नोटिस करना?
SC/ST नहीं, सॉरी मैं SC/ST सॉरी पार्डन SC/ST है। कस्टडी में 22/2/2022 से हैं।
Has been fixed for judgment आया। It has already been fixed for judgment.
फिर इसीलिए तो हम स्टेटस निकाल कर
नहीं 18/9 का रिपोर्ट।
हाँ
It is fixed for judgment.
फिक्स हो जजमेंट फिर आर्गुमेंट पर
कब आर्गुमेंट पर फिक्स कर?
देखा जाए फिर इसके बाद 14/10 को हियरिंग के लिए रखा, फिर रखा गया। लास्ट पेज से एक पेज पहले देखा जाए
नहीं ये स्टेटस नहीं, आप हमको ऑर्डर शीट दिखाइए, ऐसा स्टेटस कैसे दिखा?
ऑर्डर शीट तो निकाल कर लाना पड़ेगा मैम, लेकिन वही हो कर रहा है कि फिक्स फॉर जजमेंट कर रहे हैं फिर रिकॉल कर दे रहे हैं। एक एपीपी को कहते हैं कि एक रिकॉल पिटीशन फाइल करिए, फाइल करते हैं उसके आधार पर एविडेंस पर फिक्स।
अब बहुत सीरियस एलिगेशन लगा ये
जो हम एलिगेशन लगा रहे हैं ऑन बेसिस ऑफ डॉक्यूमेंट लगा रहे हैं, अदरवाइज हम नहीं लगाते। और इसी के चलते
एपीपी को कहते हैं कि इसको एक तो रिकॉल पिटीशन डाल दीजिए और उसके बाद दोबारा जो है एविडेंस रिकॉर्ड कर।
मेरा कहना है मैम जब 100 डेट से ज्यादा एविडेंस पर फिक्स हुआ, इसके बाद विटनेसेस एग्जामिन सब हो गए, उसके बाद कौन सा डॉक्यूमेंट रह जाएगा जो फिर से एविडेंस
मेंशन दैट इट इज फिक्स्ड फॉर जजमेंट।
लेकिन फिर से मांग लिया जाए रिपोर्ट की, फिर मांग लिया जाए कि क्या क्या डेट हुआ है। हम तो लगा इंटायर स्टेटस लगा रहे हैं रिपोर्ट का माध्यम से, कोई ऐसा भी नहीं है कि हम
ऐसा करते हैं ओपी नंबर 2 को नोटिस करते हैं और स्टेटस मंगाते हैं ऑर्डर शीट मांगा,
जी ऑर्डर से ऑर्डर
ठीक है?
से ठीक
Filing criminal appeal procedure number 533 of 25. As per the status received from the court concerned, the case which is dated 18 September 2025, the case is fixed for judgment. The learned counsel for the appellant has submitted that after sending the status to this court, the witness has been recalled and thereafter the matter is now fixed for arguments.
फिर on 14/11/2025
On 14/11/2025,
2025
the learned counsel submits that the case was running for argument since long. Earlier the case was running for argument since long, but the court was not taking appropriate steps for disposal of the matter. And it has also been recorded in order dated 11/11/2025 that the prosecution has been taking time again and again since last 1 year. The learned counsel submits that the court is totally insensitive to the civil liberties of the appellant, who is in custody since
22/2/2022
22/2/2022, and accordingly he submits that the appellant be enlarged on bail. You have filed your counter? तो उनका क्या लिखना है? अपीयरेंस लिखना है कि नॉन अपीयरेंस लिखना है? The learned counsel for the state, MS Lili Sahai, has submitted that the file has not been allocated to her but to MS Nehala Sharmin, but on account of her personal difficulty she is unable to appear before this court. The records of the case suggest that no counter affidavit as such has been filed by the state, and notice has also not been issued to the private respondent. The matter arises out of allegations under SC and ST Prevention of Atrocities Act. The counsel for the state is also directed to seek instructions and file a counter affidavit in this case. Let notice be issued to the opposite party number 2 for which recusals under state be filed within 1 week.
Yes, 1 week.
Within 1 week. Office is directed to call for the
ऑर्डर से 29/4/2025 तक, उसके बाद का मान लीजिए 29/4/25 तक
call for the order sheet from the court concerned right from 5/5/2025 up to date.
स्कैन कॉपी
Scan copy. Yeah.
बस
Let this order be communicated through fax.
कोई डेट अगर फिक्स हो
post on 28th November. Office to tax me post. So office is directed to bring the name of MS Lily Sahai from the side of the office. आप उनको कॉपी दे देंगे?
हाँ हम दे दें कल
अब ये सोचिए मत, सोचने का कोई स्कोप नहीं। भाईचारा अपनी जगह है, लेकिन जब आप हैं तो आपको तो करना ही पड़ेगा ना। If she is unable to come, तो ऐसी दिक्कत है।
Item 34, contempt within 650 of 2025.
Yes. So, we have written all the both the reason orders, and now we have accepted the date of birth as mentioned in the service section of police.
Okay.
Paragraph 24 is remain.
हाँ तो उसमें तो लिख दिया है, लक्ष्य वही पुलिस वेरिफिकेशन होना है, हम लोग लिखे हैं।
पुलिस वेरिफिकेशन तो होगा ना?
पुलिस वेरिफिकेशन
सब्सटेंशियली हो गया है आपका।
हाँ बाकी
बताइए।
नहीं तो हम कहते हैं कि जनवरी में एक डेट दे देते हैं। 2 महीना लोग उसमें है।
चलो बहुत परेशान। You take your time. I'll put it in 26 जनवरी के एक दिन पहले।
ठीक।
तो 26 जनवरी के एक दिन पहले कौन सा दिन है?
22 तारीख से लास्ट
Content Civil 650 of 2025. Suppose this case on 22nd January 2026. बस इतना ही काफी।
26 जनवरी लॉन्ग वीकेंड। देखो
अच्छा है, जजमेंट लिखेंगे ना बैठ के। आप लोग घूमने जाइए, हमारे पास काम ही क्या।
No, we mark the long weekend and keep it there priority.
You plan your vacations. We have no business to plan vacations. We only have business to plan how to write judgments.
Under heading for hearing, item 35, first appeal 191 of 2023.
What is it?
It's the case where I have sold a property to the appellant with sold the property.
First appeal है तो बहस करना होगा ना? हाँ? टाइम शुरू करिए ना, आधा घंटा है।
Appellant side करेंगे।
अपीलेंट साइड करेंगे नहीं तो क्या करेंगे?
Any date may be fixed for final decision. I'm ready on the facts. I have to do a little bit of research in this matter.
You are the plaintiff or the defendant?
I was the defendant. The cancellation of sale deed filed by the plaintiff was allowed.
फिर हम लोग क्यों ही ये स्पीड पोस्ट और पुलिस स्टेशन और क्या क्या करते हैं नोटिस सर्व करने के लिए, राइट? You're not ready, no? Let's open it. खोलिए. Start. Let's hear it. We'll read together. I have also not read it.
On facts, I can.
Start it. Who are you?
I am the defendant who sold the property to her, and he is the plaintiff in this case. So basically, with the purview of if I support her, then the only contention which she relies on is Section 44 of the TPA. The joint property can share the property, but he has to pay the for partition.
That's right.
The entire contention
हो
should
गया आपका. Decide the case.
of the appellant, I think, perhaps that would be
Yes, yes.
And I have to, on the last occasion, I had
Total 42 decimal of land was there, ladyship. I have sold 21 decimal. Admittedly, the mother
50%.
had
50%.
yes, my I have so.
And
She is the
there-
purchaser.
Yeah, I'm the purchaser. I have bought 21 decimal. Admittedly, there is no possession given to me. I'm not in possession as on date. Mutation has also not been done. Only thing is that he has, whatever my Wendy has sold me is his share of the property.
Undivided.
Yes.
Undivided share. And though in my witness, I have clearly stated that ऐसी बात नहीं है कि मैंने बिना partition के बेचा है. ये मैंने मेरे इनके एविडेंस में आया है डिफेंडेंट
You claim that there was partition.
Yes.
So even if you assume that there was no previous partition, there must be a finding that there was no previous partition.
There is no finding.
This is not true, Lordship.
There
He,
is-
he said that I am only sole legal heirs of his mother, Lordship. This fact has been suppressed in sale deed, Lordship, Exhibit 3, Lordship. हम पढ़ देते एक लाइन आफ्टर डेथ ऑफ सेठ स्वर्ण कौर एज वेल एज हर हस्बैंड गुरमी had a portion of property vested and devolved upon the seller, being his only son surviving, sir.
There are other sons.
There are other sons and daughters also.
Only
two sons.
I-
No daughters.
No daughters also.
No daughters, and there, it has come in fact also in the witness also that मेरी कोई बहनें नहीं हैं.
तो मिस जॉइंडर का बना है ना?
Miss Joinder का भी prayer था.
So what is the finding on Miss Joinder?
Miss Joinder, they said that we will not go into it. It is only on the point of cancellation of sale deed. They have gone only on 3 grounds. One, they say it is fraud because the vendee has said that he is the only son, for which the vendee has taken a stand saying that it was a typographical error. In one place, where I have said only son. ऐसा है नहीं. And I was also aware that both of them are brothers, which has come in the evidence. Second round that on which the title suit was decreed was saying that I have not taken possession as of yet. And third ground was saying that before purchasing the property, I have not done due diligence by going to a government office and finding out it. I can read the relevant part in English. At page 37, the finding of the trial court is recorded.
You read the case of the thing.
Very good. Case of the plaintiff is page 27 in English. The case of the plaintiff, as per the plaintiff short, is that his mother, Swarn Kaur, had purchased the Schedule A property from previous owner, namely Narsingh Manji, by relinquishment deed dated so and so, dated 14/7/1967, and got her name mutated in the revenue record by mutation case number 138/1972-73, and since then the rent is being paid in her name. Plaintiff is running his own business as a proprietor of BS Enterprises of Schedule A Soup property, and both his father and mother died, and after their death, the plaintiff along with his brother inherited the Schedule A property except the business owned by the plaintiff. So this is the plaintiff has categorically stated that he and his brother have inherited the property. Further in the plaintiff has been mentioned that Trilochan Singh is unmarried, and after the death of the plaintiff mother and father, the plaintiff himself along with Trilochan Singh, Rajendra Kaur and Jaspreet Singh are the only legal heirs and successors. Rajendra Kaur is the wife of the plaintiff, Jaspreet Singh is the son of the plaintiff. As per the certificate issued by the CO by letter number so dated so and so. Leadership, at this point I want to bring to your court's attention, your honorable court's attention, that Trilochan Singh is not unmarried. He is married. According to the plaintiff, the Schedule A property was not partitioned, and in the second week of March, he came to know that the property, half portion, has been purchased by Kishore Kumar Bansal and Sumit Kumar Bansal, that is me. The defendant number 2 and 3, who is the appellant in this case. From Trilochan Singh, and the description of the purchased property has also been mentioned in Schedule B of the soup property. Further, he obtained the certified copy of the sale deed bearing number so and so after 2 months due to pandemic, and came to know that defendant number 2 and 3 had purchased the property from defendant number 1 on total consideration of rupees 32 lakhs. According to the plaintiff, Schedule A and B is the joint property of plaintiff and defendant, and still the rent is being paid in the name of their mother, and the defendant number 1 has no authority to sell it without obtaining his consent. According to the plaintiff, the defendant number 1 has decreed himself as the only son of his parent, which is not true. The cause of action, according to the plaintiff, arose on 27 February 2022 when the said property was sold, and he has also paid the court fee and ad valorem court fee as well, and prayed for following release in short. Relief number 1, decree be passed for cancellation of the sale deed number so and so, by further declaring that defendant has no right, title and interest, and thus all subsequent entries, mutations be declared as void, illegal, arising out of forgery, fraud and dishonest misrepresentation in collusion with defendant number 2 and 3 and nullity under the eyes of law and is liable to be set aside. Second, decree for permanent injunction directed.
Go to paragraph 3, next page.
Yes,
This section.
Page 30. Yeah. Page 30. Yes, page 30.
On the other hand, written statement have been filed on behalf of defendant number 1, separately stating therein that the suit is not maintainable and hereby express an implied provision of law including disjointer and non-jointer of necessary party. This defendant has mentioned that the entire landed property after the death of their parents inherited by him along with him and the property mentioned in the schedule of the property sale deed has been sold by both the plaintiff and this defendant by virtue of registered sale deed dated 21/12/2016 in favor of MS Deeps on a Private Limited, represented through its director Sheila Hemram by Faith Sarana Sandhar, and delivered the possession of entire landed property to her, and thus she is necessary party of the suit. In her absence is bad. In her absence is bad for non-jointer of necessary party. By further submitting that land is in possession of tribal lady, also the DC ought to have been joined as necessary party. According to this defendant, the transfer took place in 2016, thus the suit is also barred by limitation. By further mentioning that neither the plaintiff nor he has valid title as the same has been transferred and subsequent transfer is valid or voidable at the option of the purchaser in the sale deed dated 21/12/2016. This defendant had mentioned that he had not given up his share in the land and earlier the business was run by the plaintiff under the name and style of GS and Co. after the death of the father with his consent, and the land was with other structured land machineries were owned and possessed by both of them. The defendant has mentioned that it is wrong to say that he is unmarried and the certificate of the heirship is the own creation of plaintiff by suppressing true facts, and since the entire schedule has been sold in 2016 jointly by them, thus there is no question of partition between parties concerned. Further, it has been mentioned that at the instance of plaintiff himself, the agreement was arrived between Sheila Hemram in one part and defendant 2 and 3 on the other part of entire schedule property. And at the request of Sheila Hemram, the impugned sale deed dated 27/2/2020 was executed and registered by him in favor of defendant number 2 and 3 with respect to the Schedule B property, and the plaintiff himself was instrumental in executing both the sale deed dated 21/12/16 and 27/2/2020, and thus the suit is liable to be dismissed. Written statement has also been filed by defendant number 3 separately that the suit is not maintainable and the plaintiff has got no cause of action and the suit is held by the express or implied provision of law. Further, this answering defendant has submitted that the suit is now barred for non-jointer and misjointer of necessary party. Further, it has also been mentioned that Swarn Pond had no right to purchase the suit land from its previous owner by virtue of deed of relinquishment dated 14/7/1967, and the plaintiff had got no right to run the business in the name and style of BS Enterprises, and this defendant denied after the death of the parents of the plaintiff their interest devolved in his two sons and dependent. Further, it has been mentioned that if the Rajendra Kaur and Jaspreet Singh are legal heirs and successors of Swarn Singh and Gurmej Singh, then they have not been added parties in the suit, and
this page number 11.
Thus, from perusal of the pleading as well as Exhibit 3 and Exhibit 8 as well as Exhibit 2, it is clear that the defendant number 1 has conceived that the plaintiff is also the son of Swarn Kaur and Gurmeet Singh. The defendant has also disclosed the wrong fact before the competent authority that he is only son after the death of Swarn Kaur and Gurmeet Singh and is the absolute owner of the said property. Thus, the defendant number 1 also misled the registrar concerned by mentioning a declaration in page 5 of Exhibit 3 and Exhibit 8 that there is no other legal claimant of the scheduled property except him. However, the defendant number 1 has mentioned in the defense that the same is a typing error. Concealment of the material fact and that too before the competent authority and obtain the registration in his favor can not be said to be a typing error, rather said to be misleading fact which is highly depreciated. On the point of possession, it is important to mention that though in the sale deed, that is Exhibit 3 and 8 has been mentioned in page 5 column 2 that the seller has delivered the physical possession to the purchasers, but DW2, who is himself the defendant by paragraph 26 of cross-examination, categorically stated that he has no knowledge who is in possession of the land, and further clarified in paragraph 42 of the cross that presently plaintiff is in possession of the land in question and the fact admitted need not be proved as per the law of evidence. DW3 is also one of the defendant, and para 43 he has deposed that he has not inquired the suit property in any government office prior to its purchase, which is also against the provision of section 55 of the DP Act and section 55 of the Act. Both the seller and buyer are duty bound to disclose everything to each other. In this regard, it is important to mention section 31 specific relief act, which runs as below: when cancellation may be ordered, any person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order
Where
it.
is issue number 4?
Issue number 4 is on page 13, Your Ladyship. By
Yes,
deciding the issue number 5, it has been discussed that in a cancellation instrument, the legal heir of the plaintiff who are not joined are the only proper party, not the necessary party, and in their absence an effective order can be passed. Not discussed.
What they will discuss. On the face of the document, your declaration is incorrect.
The
On
fact,
the face of the document.
Your Ladyship, but here,
So therefore, you cannot claim that property to be your undivided share. Because you are the purchaser,
No, I'm the seller.
you are the seller.
I have ability to purchase.
Yes. Now you cannot claim this transfer and claim as the undivided share of your vendor. You cannot. And then, whenever the partition will take place, how will this sale deed will be partly upheld and partly not upheld? How will it operate?
Your Ladyship, I will only step into the shoes of my vendee. There is one Supreme Court.
That's
judgment.
right. You will enter into the shoes of your vendee. What will happen to the right of other parties with respect to the property?
There are no other parties, Your Ladyship. That is my entire
Why
case.
no other
Because-
property? You have brothers, sisters,
No, Your Ladyship, there are only 2 sons, and that is what the
And
plaintiff has
daughters?
also stated.
and daughters.
There are no
Daughters-in-law.
daughters.
Daughters-in-law.
There is there are 2 sons.
2 sons. So
Two
the
sons.
property was to be divided half and half.
Yes, and he has stated in his plaint itself that half portion of the property has been sold by my brother without my consent, because there is no partition. That is what his contention is. I have sold half share, which is my share of the
Which portion
property.
have you sold?
schedule.
You have a specific boundary of the property sold?
I think so, yes. Boundary is given. Boundary is given.
Exhibit below.
So he has sold earmarked property, he has not sold undivided portion. You see, once he claimed that he is the sole owner of the property, and then he said that he is the sole of the owner of the entire property, and whatever property was there, he has sold. Right? And with specific boundaries. So how will this deed work? How will this deed work? Tell us. Can't work, no? And there is a false declaration before the registrar.
To the effect that I am the only son.
Enough.
Exhibit
That's enough.
not in the
But
mechanism.
if we see specific relief act section 31, the parties to the contract here, the agreement to sale was myself, the purchaser, and the vendor. And both of us have stated that we know about the existence of the plaintiff. So, Your Ladyship, parties to the contract have not made an allegation of fraud as such.
Need not. But the person who is aggrieved by your conduct, he has made an allegation of fraud against you. Because his property is also involved. There has been no partition. Okay? His property is also involved, isn't it?
I will examine it, Your Ladyship. I'm only seeking one indulgence to look for judgments to that effect and to examine the case, Your Ladyship.
You have sold 21 acres, 21 decimal. And what was the total area?
42 decimal.
can I?
Yes.
If the entire meaning of the observation of the learned code below harps on the purview of section 31. Section 31 also deals with the term voidable also.
Yes.
A voidable contract, per se minors, if whatever may be, if at the instance of the parties, if I have sold half of share, for example, this sale deed group, then the option of voidable is also there. If we peruse section 31 of the specific legal act.
Who will file a suit for voidable?
Yes, please.
Who shall file a suit?
No, who shall not be there. This shall not be the contention of the if the plaintiff and all the things, if the validity of sale deed is in question,
That's why it is in question.
Is in question. So how, if possible, we are here to assist minors if the purview of voidable can be carved out, because it will lead to a multiplicity of suits. Again, okay, I agree that there has been some subsection now, but if we read section 44 conjointly with section 31, then also if we research and get way out mileage, that may it the cause of justice.
Cause of justice can be solved only through compromise.
Yes, true.
No, I do not know. Because this is the kind of situation. Are you interested in compromise? Mediation.
If he can be compensated.
I will seek instructions. I also seek instructions.
It is a case for mediation.
Yes.
Otherwise लड़ते रहिए, जितना पैसा नहीं है उससे ज़्यादा खर्चा हो
गया। मैं एग्जीबिट 3 पर देख लीजिए क्या सेपरेशन ऑफ फैक्ट दी है।
मीडिएशन में क्या सेपरेशन?
नहीं
जॉइंट कॉम्प्रोमाइज बात खत्म।
ऑनरेबल कोर्ट के बोल रहे हैं कि देखा जाए एग्जीबिट 3 में कि लिखे हैं वेयर इज आफ्टर डेथ ऑफ सेट स्वर्न फॉर एजुअल एज द हरासमेंट गुरमेट थिंग harassment property vested and devolved upon the seller being his only son surviving legally and successfully then the seller
एक बात बताइए technically who has been defrauded
by the
the purchaser has been defrauded. Purchaser has no grievance. Purchaser has no grievance. Then what locus do you have? Whenever the purchaser will file a suit for recovery of possession pursuant to this sale deed, you will have the right to say that her sale deed will be confined only to the half share of the property and nothing more. Right? And nothing more. Then under such circumstances, her right will be confined to half share.
Then I will seek instructions.
Yes, you better seek instructions.
For that reason, I also stated a very outset.
यही जनाब उनको दिखा दीजिएगा, उसके बाद बताए पूछिएगा कि कॉम्प्रोमाइज हो सकता है। इसीलिए इतना बोले हम। ठीक है?
As lawyers, we have to go for service. What we have done.
The learned counsel for the parties are present. It appears that the matter can be resolved through mediation. Counsel for the parties are directed to seek instructions.
Yes.
Mediation यही कर देंगे।
सबसे बढ़िया होगा।
सोच के आइए कैसे कैसे करना है, जॉइंट कॉम्प्रोमाइज कैसे
करना है। हम लोग बुला भी लेंगे।
नहीं, हमको बुलाना नहीं है, हम लोग भेजेंगे वहीं पर, लेकिन प्राइम फेसी माइंड बना के आइए कि किस तरह का कैसा लेन देन होगा। ठीक है? क्योंकि मे बी दैट सम मॉनेटरी ट्रांजैक्शन हो सकता है, पोजीशन के बाद कुछ हो सकती है, आपस में बात कर लीजिए और सोच लीजिए कि मीडिएशन, और वापस आपस में बात करके अगर सब सेटल नहीं हो जाता है तो मीडिएशन में क्यों भेजना है, यहीं पे जॉइंट कॉम्प्रोमाइज होगा। अदरवाइज वी कैन सिंपली सेंड इट फॉर मीडिएशन एंड देन यू कैन सेटल द मैटर ओवर देयर। ठीक है? रांची का
नहीं,
जमशेदपुर के मैटर में मीडिएशन जल्दी नहीं होता। मैडम, आपके रहते मीडिएशन होगा कि नहीं होगा?
एकदम होगा, हम तो चाह रहे हैं।
कब रखें बताइए? नेक्स्ट फ्राइडे रखें, थर्सडे,
2 सप्ताह बाद।
2 हफ्ता बाद।
2 सप्ताह बाद।
ठीक।